Yes.
One more thing.
We're starting.
All right. Good evening, everyone, and welcome to the March 25th, 2021 meeting of the Ad Hoc Committee. Is there a motion to open the meeting?
I make a motion to open the meeting.
Second,
I second.
all in favor? Aye.
Aye.
Great, thank you. Any opposed? Meeting is formally open, and first order of business is approval of the minutes of the meeting, should be singular, of March 18, 2021. Is there a motion to approve those minutes as edited by me? And I think, Ellen, did you edit?
No, I just responded to your email.
Okay, all right, as edited by me. Motion to approve?
I make a motion to approve.
Second?
I wasn't present, so I
second the motion. Is there a discussion on the minutes as they were edited?
Sorry, just two things. For the approval of the minutes in the March 18th meeting, it should say March 11th. It says February 18th because I just copy and paste and don't look at it.
Well, shame on us, we missed it.
Oh, sorry. So on the minutes where it says about the approval of the minutes, it should say the March 11th meeting. That's just me copying and pasting. And then with the opening of the meeting, no one seconded the motion. So I could just put someone in there if you want.
I'm sure who.
No,
Who
you just made the motion and Mr. Carson's like all in favor.
No, I'm sure someone seconded it.
Okay.
There I go again. Well,
I'll just put you in then.
Yeah, I thought I heard myself second.
Okay. I'll just put you in.
And I'm formally retaining your firm when the Article 78 proceeding is initiated to avoid those minutes.
Thank you. I'm working on one right now.
Okay. So with the changes now suggested by Brian, or corrections that will be made, is there any further discussion on the motion to approve the minutes of March 18? All in favor of approving the minutes, please signify. All opposed? Any opposed? The minutes are approved. Thank you. Second item on the agenda is the status of the mailing of our letter to the Village of Mamaroneck employees. Nora, I'm going to ask you to come back on and fill us in.
Hi, I was just trying to check my DMS power because sometimes I don't get a notification and I don't have it. So we'll have to send another reminder.
Okay. And you also obviously all saw the communication I made to the trustees and to the mayor about getting the letter out. So on we go. We keep pushing the rock up the hill. It is a pleasure to welcome Robert Spolzino, the Mamaroneck Village Attorney, this evening. May I call you Bob?
Of course.
Thank you. Welcome. Thank you for joining us this evening. I think you probably are familiar with what our task is, which is to review and revise the Code of Ethics for Mamaroneck. We were convened in October 2020, and we have been working since that date, going section by section through the code and meeting with interested parties, with both communicating via in writing and also in person. And we thought you would be a very important person to speak with, given that you are the attorney for the village. And in order to make our meeting with you more efficient and informative, I sent to you questions, which I trust you received.
I did.
And for those of you who are not familiar with Bob Spolzino, and I certainly was not until I read his bio on his website, he has a extraordinarily distinguished background, having served as a judge of the Supreme Court in Westchester County, and very knowledgeable on the subject of town and village and municipal government, author of a great many opinions. So we're just very pleased to have you with us this evening. And so I'm going to kick it off, if I may, by if I can just ask you the open-ended question of what is your role as village attorney vis-a-vis the code of ethics?
Well, the code of ethics expressly provides that the ethics board can call upon the village attorney to basically do whatever it wants. So that's been the role I've served. When they've called upon me, I have responded to provide advice and counsel.
When did you become village attorney?
4 years ago.
And in those 4 years, can you give us an idea of how many times you've been called upon by the Board of Ethics and for what matters? Within the realm of, within the bounds of confidentiality, of course.
Right. I think there are two public matters, two publicly known matters. The trustee Santoro matter and the Cindy Goldstein matter. I think there were several other matters that I was consulted on over the years, but it's a handful. It's not more than 2 or 3 other matters.
Did you categorize them in any way?
Honestly, I can't be sure I remember all of them. There were a couple of matters involving, I shouldn't say. I get called on occasionally. They ask me occasionally to deal with questions having to do with whether a disclosure form is complete or not, whether an answer is sufficient. There were a couple of those. The others have been disqualification issues.
In those matters, did you provide a written opinion or reply to the questions that were asked of you?
I don't think so. I think I met with the board and discussed them. I don't think we provided any formal opinions with regard to the ethics board.
Mm-hmm. I'm not going to dominate this or seek to, so please, committee members, jump in with questions.
I'm just gonna run through a few things. So one of the things that we've been pulling together, which won't be part of the code itself, but it's something called a racing matrix to identify who's responsible, accountable, who should be consulted and informed. And we have the village attorney down for a few things as to be consulted. So if I could run through that quickly, if there's any questions on recusal, we have you being consulted.
We're consulted by whom?
Interesting. So that's a good question. So the individual needs to recuse him or herself.
Mhm.
The responsible party would be a village officer, an employee, a board or committee member. I have a question mark under the accountable field, so that's not the right answer. And to determine, I guess, if a recusal is required, it's to consult the village attorney and the Board of Ethics.
Well, so that comes up a lot. And the role of a village attorney in that regard has come up several occasions. I do get calls saying, can I do this? Does this require me to be disqualified? And my answer to that is always, it's not up to me. I can't protect you from a complaint again. My opinion does not protect you against a complaint from the ethics board or to the ethics board, and I don't represent you individually. So my answer when that question comes up is always, if you have a doubt, you should ask for an opinion from the ethics board. But I can tell you that here are the provisions of the code that will likely be relevant to that inquiry.
Okay. So from a go forward perspective, I should probably cross off village attorney,
Yeah, well,
because you're really saying it's up to the Board of Ethics.
that's right. I can try to point you in the right direction,
Right,
but my opinion has no legal weight. And I'm
Yep.
also not your attorney. There was one individual member of a board who was angry at me because I would not assist her. I did not advise her in advance of the conduct at issue that I thought there was a conflict. And there was a required disqualification. And I think there are several problems with that. First of all, I don't represent the individuals on the board vis-a-vis their conduct with respect to their obligations under the code. I represent the board, the entity, the village.
Yep.
And number two, my giving opinions to individual members on ethics matters would put me in a potential conflict situation if the matter comes to the ethics board and the ethics board asks me to advise them. It would be, I'd be in a position where I might have said, yeah, no, it's not a conflict to someone. And then the ethics board asked me, what do you think? How do I say something different at that point and advise the ethics board? So I try to be very careful about that issue and that situation.
so I should probably cross off village attorney in every place where I have you being consulted. Because most places I have you linked with the Board of, I found one place. Most places I have you linked with the Board of Ethics. Let's see,
Well, I'm not sure, the only response I have to that is I'm not sure when you say consulted, I don't mind being consulted and pointing people in the right direction.
right, it's really consulted for an opinion or a thought.
Yeah, but I think what I'm gathering here is that he should never be consulted by anybody but the board. And the
Right,
board
that-
should be the only person to consult him. And so I think we should remove him from the matrix. And
That's
just
what I was
place the
saying.
board there.
Yep.
And at their discretion, they choose to consult with him. And I'm hearing from him that nobody should be calling for him directly about this.
Exactly.
I actually completely disagree. As somebody who was on the board and was involved when we wrote this original law, the intention was for the attorney to essentially be a risk manager for the village and for them to advise people who are on committees and be a resource for them about issues just like this.
Yeah, but John, go ahead.
I think that's, I mean, I don't know any clearer responsibility for a village attorney than that.
But I think that responsibility comes at the direction of the Board of Ethics, right? And that otherwise, why have a board if somebody can go to the village attorney independent of the Board of Ethics, right? So I agree, he should be that position, but it should be at the direction of the Board of Ethics. Otherwise,
I think
let's
if
write the
a
rule.
member goes to a member of a board or commission, or a employee goes to the village attorney and says, I need help with this. I need a better understanding of this situation. I need advice on this. Does this constitute something that may be inappropriate or unethical? I think it's incumbent on the village attorney to give direction.
Right,
Whether
but
or not
John-
that-
Should they do
Yeah,
that
but John's-
independent of the Board of
One at a
Ethics?
time,
and-
please, one
and-
at a time.
and out-
John, let John finish, please. John, are you finished?
I think the Board of Ethics is the arbiter at the end, not the arbiter at the beginning.
Right, so I think if I'm on a board and I have a question, my first stop should be the Board of Ethics.
I completely disagree, because I think what has happened is the Board of Ethics doesn't keep a record of those kinds of discussions.
They will, under our revision.
They have not historically kept a record of those kinds of discussions. So nobody is protected.
But John, if I may, what about Bob's comment that he represents the village and he can't conflict himself by giving an opinion to an individual
Right.
or be bound to advice he gives, sparing somebody from what could be an unethical act.
I understand your point, but I think there's a divergence here. I think maybe Bob's responsibility is, as you know, the village attorney's responsibility is to protect the village, to act on behalf of the village in the best interest of the village. If getting to a point where the ethics board becomes involved, then the ethics board needs to get a separate attorney.
John, I could live with that. I'm
What is it
entirely
you can live
good
with, Mike?
Well, look, the village attorney can't represent the individual on the first hand, and then the Board of Ethics turn to him for advice on that matter. So once that happens, then you would need to have other counsel for the Board of Ethics to turn to and say, what do you think? I'm not against an attorney providing assistance here. I think the first call should be to the Board of Ethics. And if we want the attorney as part of the process, well, then we have to rewrite this whole thing to say the attorney is some role in the Board of Ethics and I don't know what the word is, but if he goes to that attorney first, the Board of Ethics can't turn to that person next. There has to be another attorney involved.
We might actually be venturing into an area which is really the province of the village attorney. So I don't know that we're discussing anything that can be written or into or out of the code. We've heard from the village attorney what his view is of this situation, and we can opine as to who should go to who first, the board or the attorney, but we're not going to tell the village attorney do it differently.
So I apologize. I kind of derailed this somewhat by going to the Racy matrix. So let's keep going through the questions we have.
That's
for
very,
Bob.
very good discussion. Very
No,
good.
and it's a discussion we should probably have separately.
Okay. Other questions from committee members? I have a list, but I don't want to dominate this. Bob, have you had situations where there have been actual conflicts of interest between your role as village attorney and counsel to the ethics board? And if so, how were the conflicts addressed?
Okay, so setting aside what we just discussed, those conflicts, there was a conflict in the Goldstein case where the village board, what happened was the ethics board submitted its report to the village board and recommended the removal of a member of the planning board. A question then arose as to whether the entire record that was part of the village, the code says that the ethics board will submit a report. The question was whether the entire record was properly part of that report and had to be submitted to the village board. Because the issue there was whether the mayor should remove that person or not. And so what I told the board that there was a conflict between the ethics board and the village board. The ethics board felt that it was bound by that the confidentiality provisions of the ethics code prohibited it from disclosing the record to the Board of Trustees. So what happened was the Board of Trustees retained outside counsel to represent it with respect to that issue and ultimately reached a resolution of that issue. I continue to represent the ethics board and the board, and we ultimately reached a resolution that was satisfactory to both the ethics board and the Board of Trustees.
Were there any other situations where you had conflicts
No.
or conflicts? What about conflicts between and among village committees, commissions, where you were called in, say, by the zoning board of appeals or by the waterfront commission or something, and you found yourself between two committees or between the board of trustees and another committee?
I mean, unrelated to ethics.
Unrelated to the code of ethics.
Okay. I don't think so. I mean, I'm sure there are issues where it becomes a concern, but I can't remember anything off the top of my head. The various boards have their own roles. And so when we were advising the planning board, zoning board, et cetera, we advised about what their responsibility is, not what the other board's responsibility is or is not. There was one situation recently where we had assisted provided legal advice to the building department with respect to a violation. The person who was the subject of that violation took an appeal to the zoning board of appeals. And I said that we had a conflict because we had advised the building department with respect to bringing the violations. We couldn't represent the zoning board with respect to the appeal. So the village hired outside counsel, separate counsel for the zoning board with respect to that matter.
Mhm. Okay. Are there any sections of the code, based on whatever experience you've had with the code of ethics, are there any sections of the code that you feel require attention, revision, omission?
The ethics code?
Yes.
Okay, so I did take a quick look this morning. I think I made some notes. There's one section that I'm not sure what it means. Section B 21-4B, this is a minor thing, 21-4B
Let me go to that. I've got it up here. 21.
-4B2. B2.
There we go. 21-4B2.
Yeah, I'm not sure what that means. The foregoing village officers, board members, and employees are listed. I'm not sure exactly what it's referring to. But that's more of a technical point than a substantive point. I also think, and this is not something that's come up, I think the second sentence, or the last sentence of that paragraph is problematic in a chapter entitled Standards of Conduct, where you have these kind of every village officer shall endeavor to pursue. It's not it's aspirational, it's a goal, but it's not a standard to be enforced. So I have a little bit of a concern about that. I have a concern about the provision that says that in February or January or February, the Board of Trustees will determine who has to submit a disclosure statement. My suggestion with regard to that is that it happen at the annual meeting and in December. And the reason for that is purely practical. There's a standard format, a standard agenda for the annual meeting. And once something's on the annual meeting agenda, it's there year after year. What's happened in the past, this has kind of slipped and it doesn't get done in January. And so then there's a question, well, who's on the list this year? And we've gone several years without a determination of the list by the Board of Trustees.
Bob, going back to 2B, 21-4, I guess the second paragraph, the one that's listed up here. Originally, and I know originally there was a list of employees based on their position, based on the fact that they had access to I believe, being able to make expenditures up to a certain level, they were expected to be on this list. And so were I believe all of the members of the various land use boards.
Yep.
And I think I agree with you. I don't know where that list may be or whether or not that list was lost or whatever. And I agree that as people get hired and moved around and titles get added, that the list should be updated. And I think we spoke with Sally a couple of meetings before, specifically about the fact that the Board of Trustees can adjust the list at any time, and it just has to be presented at a regular interval.
Right.
And, I would think that at the organizational meeting, it would be easy enough to do if the Board of Trustees, at some point in the year took a look at it and said, okay, this looks good, or we need to add this position because somebody's been, we've created a new job.
Yeah, I don't think it changes significantly from year to year.
In most cases, it doesn't, but I mean, we have a new personnel, human resources person. So that would probably have to be added, or.
And it could.
Right.
But all my point is just that it should be done in the regular course, and it's not being done in the regular course because it's not being done at a meeting where things get done in the regular course.
Right, but if we're looking at the who on the disclosure list is position-based and not a specific individual, a name,
Right.
I don't see why that needs to sync up necessarily with the organizational meeting, other than it's a calendar event.
Yeah, it's purely practical, Ellen. It's just, if you do it when you're doing all these other organizational things, it'll get done every year.
Right.
If you don't, it's going to get missed.
Okay, that makes sense. As an ex-project manager, I like things being lined up.
Mhm. Yep.
Any other section, Bob, that jumps out at you?
No, that's about it.
Okay. Moving along. Do you see any sections of the code that, based upon your rather substantial experience adjudicating New York law, is there anything in our code that you've seen that says, now that can't happen because that conflicts with CPLR, or that conflicts with the municipal law, or something like that?
Well, the only issue that I've seen where I see an issue to be raised, and I'll tell you how we dealt with it, is it has to do with the confidentiality provisions. And the ethics board has been the ethics board has taken confidentiality very seriously. There is, I think, an argument to be made that there is no explicit exemption in the Freedom of Information law for the proceedings of an ethics board. I've taken the position that the provision allowing, creating an exemption for disclosure for a confidentiality provision created by state law is broad enough to include the ethics board, because the ethics board is created pursuant to state law, and the board of trustees was given the authority to define the role of the ethics board, and therefore it's functionally equivalent to state law for the Village of Mamaroneck. That interpretation has never been tested. I'm not sure there's anything we can do about it. It's really a matter of state law that would have to be fixed rather than local law. Because I think everybody feels strongly that these provisions, these proceedings should be confidential unless and until there's a finding. So,
Bob, I confess to having lost you a little bit along the way there.
okay, I'm sorry.
If you could, no, that's me. Could you start from the beginning and
Sure.
maybe break it down a little more? Thank
Yep.
you.
Okay. So the ethics code of ethics says all the proceedings are confidential unless and until there's a finding, and then that finding, that determination gets presented to the Board of Trustees and becomes a public document. Okay?
Right.
The Freedom of Information Law of the state of New York sets up what can be confidential, or what is subject to being disclosed. And the general rule is it's anything unless the code, the Freedom of Information Law, exempts it from disclosure, right? There's no explicit exemption in the Freedom of Information Law for ethics board determinations. There is an exemption for documents that are established to be confidential by state law, by other state law outside the Freedom of Information Law. Okay. The ethics board, the code of ethics, was created as established by the Board of Trustees pursuant to explicit authority given in the general municipal law. So in terms of confidentiality, and then as you know, the code of ethics provides for confidentiality. So in terms of confidentiality, when I've been asked this question, I have taken the position that because the ethics board, the code of ethics was created by the Board of Trustees pursuant to express authority in the general municipal law, and that express authority gave the Board of Trustees the authority to determine how the Board of Ethics would operate, the code of ethics is the functional equivalent for Freedom of Information Law purposes of a state law exemption. And therefore, the proceedings of the ethics board are confidential to the extent prescribed by the code of ethics, even in the face of the Freedom of Information Law. I believe that's an accurate interpretation, but there's no judicial imprimatur on that. The issue's never been raised and decided, so it remains to be decided.
So Bob, I'm not a lawyer, so can we dummy this down a minute?
Sorry.
So, no, that's okay. What I'm getting out of what you're saying, and I may be totally wrong. So I'm on the budget committee.
Mhm.
So all of my emails are foilable, if we could make that a word.
Right.
Are you saying because of the confidentiality in regards to the Board of Ethics, their emails are not foilable?
That's correct. Their emails
Okay.
regarding ethics, investigations, determinations, all of
Yep.
those things. The only public document, the only document that ever becomes public is the determination.
Okay,
But there's nothing in our law that when the Board of Trustees created this new ethics law or the ethics law, was there ever, it seems to me that by practice, things have become confidential, not expressly by law, correct?
Well, no, the code of ethics says it's all confidential.
No, yeah, I mean, it says it's confidential, but it doesn't say that it's not foilable, correct?
Well, I understand the intent of the word confidential to mean not subject to FOIL,
right, because
not subject to
otherwise,
disclosure.
right, otherwise I could, for whatever reason, submit a FOIL request to the village about something with the Board of Ethics. Whatever that process is, which I don't know, but
Mhm.
Well, well, there are things that are foilable and there are things that are not foilable, and the things that are foilable are actual reports and you know, this goes back to part of the discussion that we've had previously, which is a request for an investigation. Certainly, the original request would be, in my opinion, foilable. Whether or not the pieces of the investigation that go on after that are foilable, you know, that I guess it's up to interpretation, but certainly the original request would be foilable.
right. So John, if I'm requesting the Board of Ethics to investigate you for whatever reason, you know, I don't like the shirt you're wearing today, but you know, whatever the
Okay.
reason is.
I'll get over it.
Yeah, good, I'm glad. Why should that be public information?
Why shouldn't it be public information? If you feel that there's a cause for me to be investigated, there should be no problem with that being a public document.
I think most ethics codes would take the position that it's not a public document. Similarly, if I make a request for an opinion from the Board of Ethics, most codes would treat that, and I think ours does, as a confidential request for an opinion.
It wouldn't be confidential. It would just, the opinion would still be foilable. It would just not be foilable with identifiable information.
Right, but if I'm accusing you of something, whatever that something is, that could be damaging to you.
Right. I think
So
we're
my
we're losing sight of two things. If somebody puts in a request for an investigation, verbally says to, somebody verbally says, I think you should investigate John Hofstadter because he's, got a shirt I don't like. That request should still be foilable. Now, whether or not my name is included, that's a different, that to me would be not included, but it's still a foilable request.
I don't know. So coming out of financial services, investment banking world, all of this stuff was kept confidential. If I went to HR, if I went to legal, if I went to compliance, Jocelyn, I'd like you to chime in if you agree, because you're also in the same background I am. If I went to any of those organizations and filed a complaint about someone, that was kept confidential until the investigation was completed.
But that's the private sector, that's on the public world. And I think at the end of this, somebody could redact the information necessary to keep it as private as possible. But we can't compare what happens in the private sector with government, in my mind. I mean,
I agree with you on that, but I think it should be the charge itself and not the person. So the charge public, the person no. But Jocelyn, was that
I
you?
agree.
I was going to make a comment about the differences because I'm currently now working, in a non-for-profit, and the rules are so different. I can't recall where we landed on anonymous complaints, though. Obviously, that where did we land on an anonymous tip to the ethics board? Because I think that comes into this discussion. Did we say that anonymous tips would be investigated, or that they had to be assigned? I think we said that they had to be assigned, but attributed to an individual, a complaint for it to be investigated. Did we land there?
That's where I thought we landed.
Okay, so we addressed the issue that what would prevent someone from making a valid inquiry to the ethics board because they could remain anonymous. So we've eliminated that. That actually, not that I'm proposing we revisit that, but there are issues that people are just afraid to be authoring, but then they just don't get to bring them to the ethics board is what we decided. I'm bringing that up because I think it's relevant that, people are afraid to be foiled, to be at the source of an issue, but they know about the issue. And if we are a village who wants for inappropriate behavior to be escalated, we have to, we don't want people to fear, retaliation, etc. But at the end of the day, the ethics board board exists because we want unethical behavior escalated, right?
Right. I want to intervene at this point because we're now talking about a part of the code that I don't think, well, maybe it does involve Bob or not, but the question had to do with the
It's what's spoilable?
yeah, and that's a matter of, it's going to be, it's at this point, it's not under review by us. It's not something we can determine whether it's foilable or not. And what Bob, the question to Bob was, are there any parts of the code which have some potential conflict? And he's given us his view on that. I think we can go back to our discussion about anonymous complaints to the Board of Ethics, but I think that's beyond what we've asked Bob to weigh in on.
Fair, yes.
Okay. So, Bob, any other sections of the code that you feel are worthy of attention?
No,
Okay. I sent to you I'm going to go down to section 2114G. We have the original, the code as it exists now says that the board may refer to the appropriate prosecutor, possible criminal violations of this chapter. And our proposed revision expands this, saying that the board can refer something to a prosecutor, the attorney general, for criminal violation or other civil legal enforcement. We've broadened the referral authority of the board, of the ethics board.
Mhm.
Do you have any thoughts about that?
Just a couple of technical things.
Yes.
The county attorney has no prosecutorial role or role in civil enforcement with regard to the village. County attorney just represents the county. If you want to define, it says appropriate prosecutor, that would be the district attorney, not the county attorney.
Okay.
As far as civil legal enforcement is concerned, I'm not sure what you had in mind there. Any civil legal action on behalf of the village has to be brought by the mayor with the approval of the Board of Trustees. So if you want if your concept is that the village could take civil enforcement, I assume you mean by an injunction or something like that. The appropriate body to send that to would be the Board of Trustees.
Okay, I was the drafter of the revision, and what I was aiming for was not to restrict
Mhm.
Board of Ethics, to shoebox them into only one kind of alternative.
Mhm.
So this is very helpful in that regard, and we can redraft this in order to make it compliant with with how civil proceedings are brought.
Yep. Okay. There is one other provision that I thought of that is just a technical thing you might want to address. It's 21-14E. And the comment is only this, that it's a provision that most people don't understand. Debarment has a technical meaning. It's you can't bid on a contract. You bid or submit a proposal to an RFP. I think it just, the people say, well, it's like disbarment. It means you can't do something. You can't sit on a board or something like that. It's not what it means. I just think the provision should explain what debarment means. That's all.
That can go into the definition section.
Good.
Is there a section of New York state law that defines it that I can cut and paste?
I'm sure there is. I'll take a look for it tomorrow and send it to you.
Great. Um, Members, committee members, any other questions for Bob?
Dan, I have two. I have two, I'm sorry. Bob, I've asked this for a number of the people who've come before us. Do you think that these positions are appropriate for volunteers, given the type of work and the amount of time that is required? And then my second half of that is, what specific qualifications do you think are necessary, given your 4 years of work with this board, that should be out there and established as a minimum?
Well, I mean, you're asking me questions that are policy questions, not legal questions. So I'll be happy.
And
to-
I do that, Bob, because you've been working closely. Yep. And the
Yep.
policy here on the first half, and I apologize, I should have put this out front, is
Yep.
that regardless of cost, because we're tasked with making recommendations for the best possible ethics board.
Yep.
And so that's why I ask you, is this possible to continue in your mind? And
Yep.
then the other half is clear. You've been working with these volunteers. Are there any qualities that you would like to see or you think are necessary, given your work in the Village of Mamaroneck?
So number one, I think that this board has to be made up of volunteer residents, because it's the sense of the community as to what's appropriate that's important here in interpreting these provisions. One of the things that I've seen in many other communities is there's a tendency to put clergymen on the ethics board. I guess on the theory that they know something about ethics, right? But this is not about ethics per se, even though it's the ethics board. It's about conflicts of interest. And in my experience here over the last 4 years and elsewhere, the role of the ethics board comes down to parsing through the language of the code and applying it to whatever the particular facts are. It's a legal task, not an ethical task. I mean, there are no, one of the examples I always use is it's probably unethical to continue to park in a space when you don't need it and there's somebody else waiting for the space, right? But we're not going to make that. That's not a code provision. That's not a code decision. The issue here is the code. As far as resources are concerned, I think there are two parts to that. One has to do with the actual investigations and hearings, and with the exception of one major proceeding over the last 4 years, there has not been, I don't think, a burden that requires additional staff for the ethics board with regard to its investigative and determinative functions. I do think, however, that there is an absolute need for some sort of staff support and funding for the training that has to go on in the village about the ethics code. The ethics board has been calling for that for, if you talk to the former chairman, Mark Ettinger, he'll tell you they were calling for that this entire time on the ethics board. So I think there's absolutely a need for staff support and funding for the educational aspects of this. And I think the biggest need for education is as to the disqualification provisions and disclosure provisions. Virtually everyone that I've dealt with in the village is very cognizant of their obligations, but doesn't know, for example, that you not only have to sit at the meeting and say, I can't participate, I'm disqualifying myself because I have a conflict. You also have to get up and leave the room. And in certain situations, you have to make that disclosure to the Board of Trustees on the record at a public meeting. So people just don't know that. So when they don't do it, then they get caught, so to speak. And they feel, it's remediable, it gets fixed. They didn't mean to violate the code of ethics, but they feel bad about it because they're generally very diligent and very cognizant of their ethical obligations.
We've actually addressed it.
Good.
Bob, and with the support of the village clerk and I think the mayor, and we, first of all, just so you know, we are proposing to move the training and education function away from the ethics board and to the village manager, with the recommendation that the village spends the money to buy, at the very least, online programs that educate employees about what the requirements are, and
Well, in
should
that
be.
regard, I'm sorry, Dave, but in that regard, just understand that the village's ethics code is not the state ethics code or the county's ethics code or the town of Mamaroneck's ethics code. So there's nothing you're going to buy off the shelf that's going to give you that training. Somebody has to develop training based on the village's, unless you recommend changing the code to homogenize it with these other codes and with basically general municipal law, which is what everybody focuses on. You're going to need specific training on the village ethics code.
Except as a base level, New York State has online available to everyone, the conflicts of interest training. So our staff can take that at any time.
Right, you have to understand that I believe deals specifically with the general requirements of general municipal law.
Yes, it does. Yep.
Which solely have to do with contracts.
No, it kind of went a little further than that.
Not my recollection, but
I did take it in November whenever they had it online.
Mhm.
But it is available to go back and look at any time. And yes, we do have more in our code than what's in that class.
Right.
But from an online training perspective, that's free.
Yeah.
And I know Mike gets upset every time I bring up, I'm on the budget committee looking at dollars. That's a very good basis for where we're headed.
Not saying it's bad,
Yep.
just that it's not sufficient.
I agree. It's not sufficient.
Yeah, I think the point is well taken. And if you're saying to us that the disqualification and disclosure provisions under our code are not well understood, then that's something that needs to be addressed specifically so that employees are not put in the position where they are embarrassed by what they didn't know.
Right.
Okay. Are there any other questions for Bob? If not, Bob, thank you very, very much for visiting with us and joining the meeting and for your contributions. It's been extremely helpful to us.
I hope it's been helpful. I'm happy to help.
And we may come back to you with some follow-up. I'll look forward to getting that definition from you.
Mhm.
And you're welcome to stay or depart as you see fit.
That's okay. My wife is waiting for me for dinner, so I will be departing.
Okay.
Enjoy dinner.
Good to see all of you.
Thank
Bye-bye.
you.
All right. Thank you.
Thank you.
Okay. So I would like to bring up the agenda. Here we are.
So before we get back to the agenda, Bob just raised a really, really interesting point on training. So if we agree that the state's conflict of interest training is not sufficient,
Ellen, you froze up.
Yep,
I back?
You're
you're
back
back
now.
now.
Okay, so if we agree that what the state offers isn't sufficient, we're issuing the code every year for people to read and sign off on. We need to figure out what the village manager's office needs to do to supplement training.
Well, I honestly think this is where the village attorney comes in as a resource and basically sits down with groups of employees and says, have you read the ethics law? Do you understand it? Do you have questions about it? And leads a seminar about it.
So then maybe it's a series of online, and I'm not saying online, just read and click, but online via Zoom, whatever, for all village employees to attend, to go through the code. I'm just saying all the village manager's office will be able to. I'm sorry, go ahead. I was just gonna say, I think all the village manager's office will be able to do is administer.
John, do you want to spend $500 an hour for the village attorney to meet with all these employees and train them?
Well, I think there's another option
Yeah.
that you could do this online, that you could do this as a, read scenarios and they react and it's a mandatory, you have to receive a passing grade of X. Like there's another way to get content understood and mandated by every employee. There's a cost to that, of course,
Right.
but there are shelf products, at a cost.
But there are not shelf products that reflect our code. Our code is more restrictive than many code in New York State as it currently stands and may actually become even more restrictive with this revision. So at the end of the day, may not be able to rely on the state to provide, that kind of, electronic class, online class.
Right, so I just think we need to figure out what it is we're actually proposing.
I would recommend that we propose whatever the best possible solution is, and we can propose other solutions, but I don't think we should be concerned with the cost.
I know you
There are
keep saying
costs
that.
associated. There are costs associated with failure to provide things that I think we're paying for now. So I just say, what is the best possible suggestion we can give to the board? Then they will make the decision. And then, Dan, if I could make a separate topic here, maybe if we could just postpone the agenda for now. I think we're having good discussion that is relevant and contemporaneous with Mr. Spolzino's appearance here, that I would rather we continue. I would make a motion that we continue with this now and continue with the agenda after.
Sure, go ahead.
I agree.
Go ahead, Helen.
No, I was saying I agree with you.
Okay, my first thing is this, that we had a lot of discussion and John brought up points too, and I think we all have a position on what is the village attorney's role. And in thinking about this, I don't disagree with John, and I think the village attorney should have a very prominent role. I just don't want to place him in a position above the Board of Ethics, or we have to factor that into changes that are going forward. My feeling is this, is that the attorney shouldn't operate independent of the board. If somebody approaches the attorney, it should be equal to approaching the board. The board should be notified, and there should be an understanding from all the board what the attorney is doing. When that happens, go ahead.
If someone approaches the attorney, I'm sorry, I'm cutting you off. But if someone approaches the village attorney should that be deferred to the Board of Ethics first or let the village attorney keep going?
I think that's what we have to discuss here. My original feeling was that the board is the most important component of this and that the attorney should act at the direction of the board. If the attorney becomes aware of something, he should notify the board there. My real concern is this, is if the board disagrees with the attorney, we just need to suggest a workaround so that there is a separate and distinct attorney that the board can turn to for advice should they disagree with the village attorney.
You can,
I think the village attorney has a legal obligation. You know, and this is where I disagree with Bob on this completely. If I, as an employee of the village, show up at Bob's office or call him up and say, I'm the recreation department head, and I have this problem, and I speak to the attorney for the village of Mamaroneck, and then it gets deferred to the ethics board. The ethics board, as we've already discussed, does not have the skill or the experience to address many of these issues that may be ending up on their doorstep, and they have to call in assistance. And I think the goal is to prevent things from ending up at the ethics board long term, and only in extreme situations should things be brought to the ethics board.
John, I agree. In a working way around this, you'd want an attorney who is engaged and available and receptive and people are comfortable coming to. But at the end of the day, who is accountable to the public or the board? Is it the attorney or is it the board? So who is the person who's ultimately responsible, or group that's ultimately responsible? And what I'm hearing is we are putting the attorney in that first position, and I don't know if that is consistent with the intent.
Seems to me the mayor and the board can instruct the village attorney not to answer such questions. I don't know that this is, strictly speaking, within the province of the code or the ethics board. If the village attorney takes the position, I work for the village, I cannot give you an opinion on this. I mean, it can get to a point where you have multiple queries going to the village attorney from multiple places, and then who's he reporting to?
And then which opinion is the village's position?
I'm not sure I understand your question.
If somebody seeks guidance from the village attorney outside of the Board of Ethics, is that the opinion we want? Should this go before the Board of Ethics? What role do they play when somebody goes to the village attorney? And if somebody goes to the Board of Ethics, are they required to go to the attorney? And if we have competing views here, what happens?
So Nora, are you listening to all of this?
I am.
As a Board of Trustee member, what's your thought?
You know, I think that there needs to be someone whom employees and land use and other volunteer board members can ask the question of, and that seems logically the village attorney. And I think in most cases that works out okay. They're just, in one circumstance, the village attorney needed to recuse, so maybe there needs to be like a two-step process. And if there is an investigation, then it's a different attorney that leads the board in that investigation. I don't know, those are one options, because I do think there has to be, it's not fair to ask people, not fair to ask employees or volunteers to have to go to outside counsel for an opinion.
Now we're talking about ethical questions now only.
Right, it's ethical questions, right, but if they have to go make a formal request to the Board of Ethics, then that can take, it could take several weeks.
It can,
Yeah,
Yeah,
and
but sometimes it doesn't have to be a formal request. It's a
oh, but that's
request.
what
All I'm saying is-
debated. That's what we debated
Who-
at great length earlier.
They don't meet on
But
a regular
who
basis.
is,
They meet once a month.
which,
So I just think there has to be a mechanism, and I don't know what the mechanism is, for employees and volunteers who are considered village officials too. I mean, you are all
Yep.
village officials now, but for volunteer
I-
capacity.
I-
To have someone you can ask, and then there could be a situation where you ask someone, and maybe it needs to be a different person.
I'm okay with the village attorney or some attorney having a role here.
Mhm.
But at the end of the day, there's got to be one person that is the ultimate determiner. And who is that? Is that the board or is that the attorney? Now, if the attorney is going to be the point of first contact, I think that's great. We should have somebody at a lower level that can work through problems at the initial stages. But then we can't ask the board, if they disagree with him, to then turn back to that attorney for legal advice. That's all I'm saying.
I think
And
you're
so,
right.
and it's got to be established in the process, who is the ultimate judge, who is going to be accountable for this decision that's provided to a village employee or a volunteer.
So, and at which point would the village Board of Ethics need a different attorney? And I also think, to the point John made earlier, that it would be very beneficial if we had these, if we had the earlier opinions. Because the Ethics Board has given opinions to individuals, and if those were redacted, there might be, case examples that could provide guidance. And if I as a trustee or anybody on a land use board or anybody in the village looked at those redacted opinions that would be on the website, you might have a better guide. You might get some information before you actually went to ask the question.
What I heard loud and clear from Bob was the predicament of an employee coming to him and saying, give me your view on this. And his saying, you can't bind me. I can give you my thoughts, but you can't take that to the bank and say, Bob said I could do this. That would create, in my mind, put him in a difficult position over and over again. If he is the final arbiter of these ethical questions.
I agree, but he could be the first person.
Go ahead.
I'm okay with somebody being the first person involved in this process and then reporting back to the board. And I think that, if I'm hearing John correct, is what we want. We want somebody to work these problems through. I think he's saying what I'm saying is, who is the ultimate judge here? And if it's going to be attorney, well, then we have to change the process.
But the attorney isn't the ultimate judge. The attorney says to an employee or a board member, this is my advice. I suggest this. At the end of the day, a board member decides differently, and I don't know that I don't think that the village attorney turns around and says, I got this request from Bob, Dave today, and I just wanted to let you know. I think that reporting structure is ridiculous. I think the village attorney is the contact person for when a board member or an employee has a question about an ethical situation. They go to him and they get advice, and then they go to whatever board they are on, and if they listen to the advice, there presumably should not be an ethical problem, but there still could be. Or maybe they didn't share all the facts with Bob and the village attorney, but whatever. that putting Bob in the situation of basically telling the ethics board about every time that he has a conversation with somebody about an ethical issue is just not workable. I think the reality is it has to, an employee has to be able to go to, or a board member has to be able to go to the attorney, get advice, take an action, and then be responsible for that action. And if it turns out that there's an ethical issue and somebody else files a claim against them, then the ethics board takes it up and they have to get different legal advice because Bob has already weighed in on, or the village attorney has already weighed in on it. I don't see what the
All right.
problem.
So that gets back to the racing matrix to an extent, where Bob was saying, maybe I shouldn't be consulted on all this stuff. It should be the Board of Ethics. But maybe when we start documenting our procedures and training for village staff, it's who do you go to? Do you go to the Board of Ethics or do you go to the village attorney? What is your first stop? And I think that's
I
what
agree.
we need to get out to people. Who do you go to if you have a question?
I agree. And John, I hear what you're saying, and I agree with what you're saying, that the board has access to another attorney, so when there's conflict there. So if I'm hearing you right, and I could go with this, is that the village attorney is the first stop or an available stop to provide guidance and direction. So long as the attorney reports it to the board and that the board has the final sign off on it, I could live with that. I think that that would be great. And that when the board has conflict with the attorney's decision, not an individual, by majority vote of the board, and I think that's what happens there, that they have access to outside counsel to consult with and say, okay, what do we want to do here?
Okay, I'm going to give you a real world. I'm going to give you a real world example of something that occurred. The village had hired an attorney when I was on the board, and I was, involved in rewriting the ethics law with this village attorney. And I basically said to the village attorney, when we were going through the ifs, ands, and buts about, committee members and board members and what their responsibilities were and whether or not they could appear before other committees and things of that sort. And I said, look, I'm a real estate agent. I work locally. Are we creating a situation here where I would be precluded from appearing before any other board or on behalf of my clients because I'm on the board of trustees and I'm beholden to the ethics law? And that attorney said to me, no, you basically, it wasn't about me appearing before any of the boards, but just that my clients would appear before a board. And they said no. The attorney said no. You would not be able to appear before a land use board for a client though. And I said, okay, I understand that. That never went to an ethics board, review. And why would the attorney turn around and say to the ethics board, okay, I gave my opinion on this, but what do you think about this, guys? I think that just would create an environment that would just create a backlog that would just be incredible. I think the biggest issue is the employees and board members need a resource to go to, which should be the village attorney, to give them general guidance. And the ethics board is the board of last resort. And I don't think the idea that the village attorney should be reporting to the ethics board is ludicrous.
But I think the first stop should be the Board of Ethics, not the village attorney.
I think we've shown that the Board of Ethics is not, I think we have discussed at length the fact that the Board of Ethics is not prepared to do something like that.
Sure.
And John, I agree with you. I question whether volunteers can do this. I just think we have to establish the process.
I don't know
It's
that
got
we
to
can
be
establish
a very clear understanding.
I don't know that it's within our remit
Code
to
to do it.
establish a process.
Well, no, I
We-
think we can make a recommendation, Dan. I
Sure.
disagree. And I think we're tasked here with reviewing the entire ethics process. And if we identify a potential gap or an area that can be improved upon, I think we can make that recommendation. And I would say this, if we're having some conflict here with the role of the village attorney, I think we should, as a group, are exploring it properly and make a recommendation, which I think much of us could live with, just so it's clearly established that the village attorney is the appropriate first step and that he must report this to the board for approval or just for their information. And if the board chooses to take further action, they can.
I agree with you, Mike, that I think even though it's not part of the code, we can recommend a process. So I'm going back on my work background. The last few years, I was working on many projects supporting legal regulations, working with compliance, working with legal. And one of the biggest things was a process map. It's not, can we support the new regulation? It's how are we supporting it? And that becomes one of the most important things. We can write the best piece of code that's ever existed. If it can't be supported by a process, it doesn't matter.
I think we run the risk of if you have a person who goes to the attorney to ask for advice, turn around and have that reported out from the attorney, and there may be nothing to it, just a misunderstanding of an application of the code. To have that turned around and reported out to the ethics board, just you will disincentivize people from trying to follow the code.
But John, shouldn't we document these things for future use and review? And so, I know we've talked about that, and that's got to be the part of the process, even for the protection of the person who appears before the attorney and says, I'm seeking this information.
I understand your point, and I do agree that there's some value in that, but I don't know that the village attorney turning around and saying, I got a call from Bob. Bob wanted to know about this. I told him this, and I think that puts way too much ambiguous information into the ethics board's hands.
I would like to suggest that if we are to make a recommendation on process, that one or more of you draft such a recommendation, and then we can, towards at a next meeting, future meeting, come to an agreement or not an agreement and submit to the Board of Trustees a recommendation or alternative recommendation on the grounds that the process is important. So I would think I think the views have been put forward rather clearly. Now I suggest to you that those of you who have a view, draft something.
And I'll volunteer. Once we agree on whatever that process is, I'll put together a process map. You may as well use my expertise. So in addition to the racing matrix, I'll do a process map to support it.
Okay.
But can I ask one thing, Dan? I agree with you, but I think we're having good discussion here, and I would like to continue this at least for another 5 or 10 minutes at the next meeting, because I don't think we're all that far apart. I think we're agreeing on a lot of this, and I think we need to have a little further discussion before we get to the point where we're going to put something down and say, this is a recommendation or recommendations.
I'm fine with that, Mike, but I think the appropriate next step is to put the process in draft form, circulate it, so we have a basis upon which to have that further discussion. And I agree with you. I think we can't possibly come to a agreement on this, but I think it needs to be written down so we can address something specific rather than each other's conversation.
Okay, for me, and just going forward, I find the two conflicts we have here is who is the primary provider of that final advice? And then what process do we want to have? Does anybody disagree? Meaning the primary provider being either the village attorney or the board. And then what is the process for that person to make, or persons to make that decision?
Do you mean initial rather than primary?
Initial primary, who does the employee or the board member go to? And then
First.
how does that person, how is that person charged with making that decision or empowered?
All right, I suggest that whoever has an articulated view on this, draft it and send it around so we can have a basis or a ground for further discussion on this, and we'll put it on the agenda.
With the approval of the rest of the committee, I can send something, Ellen. I know you said something, but I think it's important that John participate in this too, and that three of us are sending it together. Because again, I don't think we're all that far apart. I think we can work this out.
Right, but I think the basic difference is, I believe the first stop is the Board of Ethics, and I think John thinks it's the village attorney, unless I misunderstood him.
You're correct.
All right.
I don't believe the village attorney, I agree with Mike that the village attorney should keep a log of, these questions that they get asked. But I don't think they should be turning around and dumping it off to the ethics board. To me, the ethics board should be, at the end of the day, a member of a board, it's solely up to a member of a board whether or not they recuse or not. It's not up to the ethics board to make that determination.
Okay.
Right,
I think
but
we're-
if we look at this, there's one section in the code.
You froze again.
While she's freezing, I agree with you, John. It's up to that individual. But that's it. Who is their primary point for seeking confirmation, or guiding them? And that's where the conflict is whether it's the attorney or the board.
All right.
I don't think the ethics board is, skilled enough, and I'm not, not throwing ethics board members under the, rug. I don't mean to do that, but as in general, I don't think ethics board members would be skilled enough to understand municipal law to give appropriate advice in specific circumstances. I think in unusual circumstances, they will be required to have an attorney who is very skilled in municipal law, guide them through whatever hearing may arise as a last resort. And
Okay, but John, let's talk about day-to-day stuff. So I've got whatever stupid issue is. I don't like your shirt. I'm back to that.
Would you give up already?
I can't even see your shirt, so I have no idea what you're wearing. And I'm going to go to the ethics board if they feel they don't have the knowledge, or
See, but I think that's
or they're conflicted amongst themselves. They then go to the village attorney, because the village attorney is here to represent the village and the Board of Trustees, as is the ethics board. So it's, to me, where do you draw that line?
I mean, my question to you is, are you a village employee who has a problem with me because of my shirt? Or are you, or a committee member who has a problem with my shirt? Or are you just somebody in the public?
I don't know that it really matters. I
Well,
am
I do think
saying,
it matters. I mean, I
I
think,
don't know that it
I think it
does.
matters in that if you're a village employee or a committee member, you go to the village attorney and say, you don't like my shirt. And the village attorney turns around and says, you know what, you don't have a case. So there's really, there's nothing ethical about that.
Right, but why can't the Board of Ethics say to me, are you friggin' kidding me? You know, there's no issue here.
They could, but I think waiting until they meet on a monthly basis is not a viable thing, especially when somebody says, okay, John Hofstetter has an ethics charge brought against him.
Right, but if we go back to our earlier discussions with Mark Ettinger, and actually everybody else from the Board of Ethics was on the call, they respond to emails all the time. So it's not just.
Can I interrupt? I want to interrupt. They are a
Sure.
municipal board. They cannot make a decision via email. They have to have a properly noticed meeting to give an opinion. So they can't respond to an email. They can't give an ethics opinion over email.
So Nora, if I, claim something stupid, I don't like John's shirt. Mm-hmm. Yeah, and that really is stupid. They can't say to me that has nothing to do with ethics.
No, because they can't, not one person cannot speak for the Board of Ethics. They speak as a board, and in order to do that, they have to have a properly noticed meeting.
Okay.
So that's a limiting factor in this.
And they have to take it, and they have to take it up at the meeting. It can't just be,
But then can the attorney give an opinion that then the board has to adhere to?
No, the attorney could give a completely separate opinion. The attorney could say, you have nothing, and Ellen could still go to the ethics board.
Right, but if I go to the attorney and say, I don't like John's shirt, and he says to me, deal with it, what does that mean?
Look at 2116A, which we drafted into the code. No verbal communication and only written advisory opinions may be deemed binding upon the Board of Ethics and the village.
Right, but based on what Nora just said, it's not just the written answer, it's got to be approved at the monthly meeting.
Right.
That's correct.
If it's an ethics board opinion, I think the question here is, what's the first thing you do, like, to determine whether you need to go to the ethics board? Who do you ask for a baseline opinion?
Right.
That's the question. That's the question at hand. But to get an ethics board opinion, you have to, whether you do it in writing or not now, they have to meet.
I guess where I'm coming from in total is, and I have no idea what the content of the questions are from, potential employees, of the village attorney or the Board of Ethics. How much do we want to bother a village attorney? And I know, Mike, don't yell at me, who currently is outside counsel who we're paying for.
Well, I would say two things. We're really exploring and getting an in-house village attorney. And I think it's on Bob's retainer, so I don't know whether he actually would charge for this. That's a Bob question. But I think the other thing is, it might be helpful to get the list of opinions that have been given, which we haven't. So there might be some, we might have done a lot of the homework already, but we just don't have those written opinions, and that might be helpful. And I don't want to interject because I feel like I'm just your tech person.
You're not just our tech person. You're someone who's adding valuable information.
Well, thank you.
I agree.
Thank you.
All right. I'm going to exercise chair's prerogative at this point and cut off debate.
Oh, come on, Dan, give us another 10 minutes.
Oh,
I'm only kidding.
I haven't had dinner yet, Mike.
I'm only joking.
This is, well, you all have surfaced a very good issue. So I do think it would be useful in continuing this discussion to at least draft a view on this, circulate it, and that will bring us to resolution, I think, more efficiently and swiftly. And if we wind up ultimately disagreeing, we will do what we probably will be doing with other sections of the code, and that is reporting out to the Board of Trustees that we think this is an important issue that requires their attention. Here are different views of the ad hoc committee. So thank you all for that. We're now at the past the hour and a half mark. And I thank you all for the additional time and patience for this evening. This was a great meeting. This is a very, very good meeting. So we'll continue next week with this subject and the other sections that are in the notes that I sent to you. Just please give some thought to what I suggested about dividing up the code and each of us editing a separate section of the code. If you have another suggestion, please circulate it. All right, any other business for this evening?
So Dan, I will say right now, in answer to your dividing up stuff, I will clearly, based on whatever we agree on the writing in the code, I will make sure the racing matrix is in alignment, and I'll do whatever I can in terms of process mapping. So it's very clear what the order of events are.
Great. Great, thank you.
Which was not one of your options in your email request. I'm adding new option.
Okay, put it in writing, please.
Yep.
Any other, and no pride of authorship here. If you think that my suggestion really is no good or requires drastic revision, let me know. It's as I said, there's we are a committee. So
I think we, as a committee, I think we've done a great job in agreeing where we've disagreed initially. And the biggest outlier right now is input from village employees.
okay. Any other business before us this evening? If not, thank you again. I'll entertain a motion to adjourn.
Make a motion.
Second,
Second,
discussion on the motion. If no discussion, all in favor, please indicate.
aye.
Aye.
Thank you all. Have a wonderful evening and weekend, and we'll be in touch. Thank you.
Thank
All right.
you.
See you
Good night.
next week. Bye.
Bye,
Bye.
guys.
Good night.